Many times, clients contact my office and ask if they have grounds for a restraining order in New Jersey. To obtain a final or permanent restraining order in New Jersey, you must have a trial. The trial will be before a superior court judge, and the judge must find that a predicate act of domestic violence occurred, that there is a prior history of domestic violence between the parties, and that the plaintiff is reasonable to be in fear for their safety and needs the protection that a restraining order provides. The plaintiff must establish all three of those evidence by a preponderance of the evidence. This is a civil standard of proof as opposed to a criminal standard, which is beyond a reasonable doubt, we're all familiar with. Preponderance of evidence means more likely than not. So 51% standard, can you prove an act of domestic violence? Any of the acts of domestic violence are fine. Stalking, harassment, assault, terroristic threats. If a plaintiff alleges 3 acts of domestic violence and the judge believes that only 1 occurred, that is sufficient. If he or she can establish any of the acts of domestic violence that they enumerated in their complaint, that is enough for that element of proof. Then, a prior history of violence between the parties typically is required. If, for example, there is an extreme act of domestic violence, the predicate act, someone's jaw was broken, someone was stabbed, it's a very serious assault, then no prior history is required. But in most cases, the plaintiff must prove that there's a prior history in addition to the incident which gave rise to this temporary restraining order. Lastly, the plaintiff must show that it's reasonable that they are in fear. This is a reasonable person standard. So if the plaintiff is very afraid, but they have their own psychological issues and maybe a reasonable person in this scenario would not be afraid, that is not enough. A reasonable person in the plaintiff's shoes must be afraid of the defendant to establish this element. This is the case law of Silver v. Silver, and it requires the person be afraid and then they need the protection that a restraining order provides. If the plaintiff can establish all of these elements by testimony, evidence usually includes text messages, voicemails, hospital reports, photos of injuries, witnesses, other people who saw the assault, other people who saw him threatening her. These witnesses cannot get on the stand and say, the defendant is a bad guy, I know he's a bad guy. That doesn't work. The witness must have personal observations of the incidents of domestic violence. If that is the case, they will be allowed to testify. If not, the judge typically won't allow the testimony. If the plaintiff can prove all 3 of those elements, then a final restraining order should be issued. It is permanent in New Jersey, never expires. The defendant gets fingerprinted, placed in a statewide database for domestic violence offenders, and the plaintiff gets the protection that they need. If you need assistance getting a restraining order in New Jersey or defending against one, contact my office anytime. We always provide free consultations and are happy to help.